Lordship, this is an anticipatory bail, my lord.
Who is the petitioner?
Lordship.
Pass over.
Much obliged, Lordship.
Please, Lordship. Lordship, this matter may kindly come end of the board, Lordship. May kindly come end of the board, Lordship.
End of the board.
May it please your lordship. My lord, in this case, I am in a very tight situation. First thing, my lord, there is a strike in district council, my lord. They are not in a position to send me the affidavit, my lord. First thing, that my friend is also aware of that, my lord. Second thing, my lord, if my lord may kindly produce the writ petition, my lord, the matter has become infructuous. Because the appointment which they have challenged, my lord, it was only for 3 months. Now that has been expired. Now, whether that has been extended or not, my lord, or some other person has been appointed or not, that I have to find it out, my lord.
As on date, I'm continuing in the said post, Lordship. I'm still functioning as a governor, Lordship.
That is incorrect, my lord.
Lordship, let the district council come out with instructions.
Not instruction, I will file an affidavit. Instruction, I
file
have.
an affidavit, Lordship. Still, they have not filed a counter affidavit.
Because I have already forwarded the letter and all, my lord, that I have written to them for Parawise comment, but they are telling me, my lord, the difficulty is this: the staff of the district council, non-gazetted employee institution, they have blocked, my lord. They are not even allowing anyone to enter in the office. That is the problem, my lord, we have.
Lordship will not file our affidavit.
You are for?
Respondent number 6.
Mr. S.D. Leonard. You are standing counsel?
Yes, my lord.
Leonard standing counsel. GTDC has submitted that the affidavit in opposition on behalf of the respondent GHDC.
125, my lord.
Respondent 125 oblique GHDC could not be filed today since specific instructions have not been received on account of a strike by the employees in the office of the said respondent. Accordingly, it's prayed that sometime may be allowed for the said counter affidavit in opposition to be filed. Pray allowed. Mr. Leonard Counsel for the respondent number 6 has submitted that no counter affidavit will be filed by this respondent. Okay. 2 weeks.
My lord, I'll pray for 3 weeks, my lord. I'm in a very tight situation, my lord. The secretary is finding very difficult.
As prayed for, this is matter of the 3 weeks.
Highly.
Item number 2.
Please, Lordship. Lordship, I'm praying for some time to file an objection against the amendment. We're praying for some time, Lordship.
Lordship, we had filed a missed case on the last occasion, Lordship.
What are the contents you wish to?
Lordship, the prayer portion, Lordship.
Prayer portion.
Lordship.
Without touching the any of the averments.
No, Lordship. The averments are already there, Lordship. We're just tailoring the. Lordship, the main issue in question in this writ petition is regarding the authority of the respondent's aim to collect toll or to levy toll in that notified export route, Lordship. To that effect, Lordship, we're just making a small short prayer, Lordship.
So what is there to respond? Mr. Shule?
May it please your Lordship. Lordship, that part of the amendment which they have sought to incorporate, Lordship, that is directed against the CM of SORA. So the CM of Sora will, but so far the state is concerned, Your Lordship, will reply by means of oral objection, Your Lordship. Whether that will be allowed or not.
Lordship, I pray that.
But if there are, there are already relevant amendments made. See, prayer, what is a prayer? It is just a concise form of what has been stated in the main petition.
As a matter of fact, Lordships were in this matter, Lordship, when we had carried this matter to the division bench. The division bench had actually relegated the matter, Lordship, and had put in a paragraph in the judgment. It's a next, Lordship, in the Miss case, where the issue in question involved in this matter, Lordship, pertains to what we want to amend it, Lordship.
Lordship,
The counsel for the petitioner has submitted that an application has been filed. An application on the order of 6 Rule 17, read with section 151 CPC, has been filed seeking permission to amend, particularly the prayer portion of this writ petition. Responding to this, Mr. Learned Counsel for your respondent number
6 and 7.
6 and 7. You are CM of Sora.
Yes, Your Honor.
Oblique CM of Sora has submitted that he may be allowed to file a response to this petition. Next, Mr. Anticipatory, Learned AG, appearing for the respondent's number 2 and 3, has submitted that no written response will be filed by the state respondent, but would advance oral argument when the matter is taken up for hearing.
Your Honor, if I may pray that let this matter come up on the 18th, Your Honor.
Any other respondents? What about you? Respondent number 1 as well as respondent 4 and 5 have also made similar submission and have maintained that they will not file their written response in this regard. You said 18?
On the 18th, Your Honor.
On prayer made by Learned Counsel for the respondent number 2, the written response is allowed to be filed within the next date fixed. List this matter on 18th.
Highly objection.
Item number 3.
Lordship, these are Assam rifle matters, Lordship. Seeking the rank status pay of warrant officer, Lordship. The Lordship had already.
This is from CAT?
No, Lordship. It's not. It is a fresh matter, Lordship. Your Lordship had on one occasion disposed of on similar matter, Your Lordship.
Why has this matter been? Is this within the court's roster?
Because recused by court number 2, Your
Or
Lordship.
accused?
Has come. Lordship, we are seeking same orders passed by Your Lordship, same benefit. Your Lordship has already dealt this matter, so we are seeking the benefit of that judgment, Lordship. So far as the petition is
With regard to pay?
Lordship,
Pay or,
warrant officer, Lordship. Rank status and pay of the warrant officer. These are Havaldars, Lordship. Now, in those cases which your lordship has also
You
dealt,
want
those are
them to
household
be, to be equivalent with a warrant officer.
Yeah, lordship.
Well, in fact, we have preferred an appeal. The appeal is still pending with the division bench.
In this case,
In this,
Lordship,
in the other matter, madam,
we seeking
on which they are seeking reliance, madam.
195 is the order, your lordship. 195 of the petition is the order which your lordship had passed.
Because that is before the division bench of Honorable Chief Justice and Justice Thank you, my lord. So that's why Justice Thank you is recused the matter since he's
Ceased of the
seized of the appeal,
that appeal
my lord. That appeal is still pending, my lord.
still pending. What do
Lordship.
you do? Because again, you see, whatever outcome of the
My lord.
appeal will have a bearing on this.
Direct bearing, my lord. They are
as well as
relying
the
on
other
that
case.
judgment
If
only.
you say that, you see, you are depending on the other case passed by this court, rather passed by me,
My lord.
which is under challenge.
My lord.
lordship,
you'll have
not just this one order, your lordship, but even the other orders also which has attained finality from the Honorable Supreme Court, lordship. This is only one of the orders. This is only like the current order which
We
we
can
are
wait for some
seeking.
time, my lord. The division bench is already is ready for hearing, my lord, any day. Whatever the outcome, we will be covered with that.
Because that bench is not regular per se, your lordship, and there's no stay order also, your lordship.
But you see, once it is made known to the court, then it is propriety demands that.
Well,
or rather,
one more date, my lord. If
judicial
one or two
discipline
dates,
demands that courtesy be shown. What we can do is, when is the
The date has not been fixed because that bench is not regular.
Not the regular bench. my lord.
probably it will sit
It will be taken up, my lord.
sooner than later.
My lord.
So we'll put it off for 3 weeks then.
3 weeks.
Can it be 2 weeks, your lordship? Because
We don't know. We see when that bench will be sitting.
3 weeks then, your lordship will come. Because
Moreover,
Hopefully, let's if it sits
three
within the 3
weeks,
weeks
we'll see, my lord.
and the matter is disposed of, then
My lord.
otherwise then we'll see how it goes.
My lord.
because in one of the orders also your lordship is part of that bench. Now those orders have been assailed by the Assam Rifle before the Supreme Court. Now there's no stay order also to that effect, your lordship,
By the Supreme Court.
by the Supreme Court, your lordship.
This kind
In
of
the
a
case of
stay
Mahesh Kumar.
stay is not required, my lord. When the appeal is notice has been issued in appeal, my lord.
Stay is not
In light of
No,
those,
but you see, if it involves a question of execution
My lord.
or putting into operation the the effect of the order, then actually stay is definitely required.
but since
But
I'm-
anyway,
I should try after
After
3
3
weeks.
weeks.
okay, 3 weeks. On premier parties, this is matter of 3 weeks.
Complete.
Item number 4.
Same matter, your lordship. 3 and 4.
But the date has been fixed, my lord, before division, 18th September. my lord.
That is only a tentative date, your lordship. Because
18 September
But 18th
the
September.
Honorable Chief Justice will not be.
for those that appeal before the DV.
Yes, my lord.
That is only a tentative date because even Chief Justice will not be.
Okay, we'll see what happens.
After 3 weeks, lordship.
Fine.
Complete.
Come 4. You go.
Item
3
number
and, 3 and 4.
No, it's 3 and 4. Same order.
Same order. Connected matter.
Item number 5.
Obliged.
Good morning, Your Lordship.
Yes, where were we?
Lordship, we were, as per the last order, both parties were directed to obtain authorities and place it before the court
On what?
on the aspect of bail application being filed by any other person besides the accused person, whether it's maintainable or not. So I had strenuously argued, Your Lordship, on the last day as well, and looked for authorities as well. I couldn't find any which speak clearly on this particular point of law. And I had also argued on the last occasion, Your Lordship, that in the absence of rules which prevents the petitioner from filing an application, it has to be held that it is maintainable, because that has been the practice for over 12 years now. And we read section 437, 439.
See, Mr. Eda, what you can do is you can rely on precedents. Whether it has been the practice in this court where such application more often than not were preferred by other persons other than the accused person. Let's put it this way: the accused person who is in custody.
Not sure.
So that will at least that will suffice. This court will take note of the same and say that this has been the practice here.
I understand.
Since in absence of specific rules, then we have to depend on other sources.
So in that eventuality, I
think if I recall, this is usually the practice here.
My lord, it is
Anybody can
the
just
practice.
come file an application because the accused is languishing in jail.
Worship, I stumbled upon one judgment of the Honorable High Court of Alabama, wherein such a question arose, although not much in peculiar to this set of circumstances, but such a question was what happened in that case was the affidavit was sworn by someone else besides the applicant. The High Court simply asked the registry if it is barred by the rules of the High Court or not. The registry gave an answer in the affirmative that yes, it is allowed. That application was entertained thereafter. I have that judgment with me if it may be of any help. Excuse me. I'll start from the beginning, Your Lordship. Heard learned counsel for the applicant and heard the learned additional government advocate for the state. On the first date of admission, the court has passed order dated such and such. Heard learned counsel for the applicant and learned EGA. This is an anticipatory bail application filed by one Rahul, son of Indrapal. However, the affidavit has been filed by one Pradeep Kumar. So they have also raised this point, Your Lordship, in that argument of theirs, that the affidavit can only be sworn by the accused. I'll just continue to read. The passing section of the registry has not pointed out any defect while passing this application. Therefore, the concerned officer, section officer of the passing section of the registry shall submit a report along with an order, if any, explaining the fact as to whether along with an order, if any, explaining the fact as to whether, in anticipatory bail application, the affidavit can be filed by any other person than the applicant of the application. If affidavit cannot be filed by any other person other than the applicant, then the reason be explained. List this on the 1st of August. I'll just take you to the paragraph which has been quoted below. In compliance of the same page, just a few lines thereafter. In compliance of the aforesaid order.
Yes,
in compliance of the aforesaid order. The concerning officer, official of the registry has filed office report which reads as under. It is made clear that the instruction aforesaid must be strictly adhered by the session court where such application is preferred. However, while presenting an application under 438 of the CRPC before the High Court, the requirement of filing affidavit as per instruction number 2 shall be subjected to the provision applicable for filing applications under section 439 of the CRPC as prescribed under the Allahabad High Court rules. The rules of 1952 relating to the application under section 439 Code of Criminal Procedure shall be applicable for the application under 438 of CRPC. The relevant extract of the order dated 8/8/2019 has been shown to this court by Mr. Kuldeep Rahi, section officer. And in the concluding paragraph,
yes.
Therefore, now it is clear that the application filed under section 438, the affidavit can be filed by the Poroka in the same manner as has been filed under 439 CRPC. So, similar question had arisen. Question was asked to the registry as to why did you pass this application? Are there any rules which prevent such a practice? They said no, it is permissible. So that is all that I've got in this regard, Your Lordship. And well, later the rest of the paragraphs discuss about the merits of the case.
Yes, I think this is good enough.
If I may so say, sir, the rules, if read again, do not speak about anything in this regard, and that an affidavit filed by any other application preferring a bail application next to a bail application. Excuse me. Excuse me.
My lord, even though these judgments which I am relying, my lord, this is not on the bail application. However, my lord, the similar principle which I believed may be applied in this present case, my lord. If my lord will come to the first judgment, that is Simranjit Singh Man versus Union of India.
I do not.
SCC. Paragraph 7, my lord. I'll just read out. Ordinarily, the aggrieved party which is affected by any order has the right to seek redress by questioning the legality, validity, or correctness of the order, unless such party is a minor, an insane person, or is suffering from any other disability which the law recognizes as sufficient to permit another person, the next friend, to move the court on his behalf. If a guardian or a next friend initiates proceedings for and on behalf of such disabled aggrieved party, it is in effect proceeding initiated by the party aggrieved and not by a total stranger who has no direct personal stake in the outcome thereof. In the present case, no fundamental rights of the petitioner before us is violated. If at all, the case sought to be made out is that the fundamental rights of the two convicts have been violated. The two convicts could, if so minded, have raised the contention in the earlier proceeding, but a third party, a total stranger to a trial, comments against the two convicts, cannot be permitted to question the correctness of the convictions recorded against them. If that were permitted, any and every person could challenge convictions recorded day in day out by court, even if the person convicted do not desire to do so and are intended to acquiesce in the decisions. If the aggrieved party invokes the jurisdictions of this court under Article 32 of the Constitutions, that may stand on a different footing as in the case of A.R. Anatoli versus R.S. Nayak. However, we should not be understood to say that in all such cases the aggrieved party has a remedy under Article 32 of the Constitution. Unless an aggrieved party is under some disability recognized by law, it would be unsafe and hazardous to allow any third party to question the decisions against him. Take for example a case where a person accused under section 302 IPC is convicted for a lesser offence under section 324 IPC. The accused is quite satisfied with the decisions, but a third party questions it and under Article 32 and succeeds. The conviction is set aside and fresh trial commences, ends up in conviction of the accused under section 302 IPC. The person to suffer for the unilateral act of the third party would be the accused. Many such situations can be pointed out to emphasize the hazard involved if such third party's unsolicited action is entertained. Cases which have ended in convictions by the apex court after a full gamut of litigations are not comparable with preventive detention cases where a friend or next of kin is permitted to seek a writ of habeas corpus. We are therefore satisfied that neither under the provision of the code nor under any other statute is a third party stranger permitted to question the correctness of the convictions and sentence imposed by the court after a regular trial. On the first principles, we find it difficult to accept Mr. Sodhi's contention that such a public interest litigations commenced by a leader of a recognized political party who has a genuine interest in the future of the convict should be entertained. Now, my lord, the second judgment.
See, Mr. Era, I'm just thinking, if this court is called upon to decide on this issue, then it'll take some consideration.
My lord.
All these authorities have to be looked into, then it has to be digested, then some decision has to be made.
My lord.
That's number one. The safer option would be for you to withdraw this petition, with liberty to file a fresh one, get the necessary signature from the
accused
himself, and come back.
Okay.
That would have been
but that would be just avoiding the issue.
No, that is what that would be avoiding issue, no doubt, as far as this matter is concerned.
Yes.
But if I'm saying that is for your own convenience.
Yes.
But if this court is called upon to decide on this, it will decide, no doubt.
Yes.
But that would consume, at least some time. And the main issue, as far as your prayer is concerned, that would be
then we can
shifted to the back burner.
We have to
for the time being.
Right, then we can go into the merits of the case. However, if this issue has been raised, it must be decided at some point of time. That is also there.
If you insist, then of course.
Now,
my lord, the second judgment which I have relied, my lord. If my lord will come to paragraph 13. It says, my lord, paragraph 13, page 13, the second judgment.
Yes.
It says, my lord, on a collage of the judgments so rendered by the Constitution Court, what can be unmistakably gathered is that the power of attorney holder of an accused cannot maintain a petition, be it under Article 226 or 227 of the Constitution of India, read with Section 482 of the CRPC, or criminal petition under Section 482 CRPC. Therefore, I hold that the present petitions filed by the power of attorney holder of the accused, without seeking any permission at the hands of this court and without even narrating in the petition that he is personally aware of the fact of the case, the writ petitions filed under Article 226, 227 of the Constitution of India, read with Section 482 of the CRPC, is per se not maintainable, as the accused cannot be represented by a power of attorney holder and does maintain the subject petition. Coming back to the fact of the present case, it is apparent that the multiple cases are pending against the petitioner number 1 to 4. They are proclaimed offender in some of those cases, including the present case, and serious allegations have been personally levelled against the petitioner number 1 of siphoning off crores of rupees and fleeing to US. A proclaimed offender cannot seek quashing of the FIR on the basis of a compromise. More so, when he is absconding in multiple cases pending against him, he cannot short circuit the system by filing petitions through power of attorney unless he is a minor in sense suffering from disability or for certain compelling circumstances is unable to appear in person. In the present petition, no such situations exist enabling petitioner number 1 to 4 to file the instant petition through power of attorney. Therefore, in cases of present kind, the ends of justice would only be served by the accused submitting to the jurisdictions of the court, after which they would be at liberty to avail their remedies in accordance with law. Now, my lord, what happens in cases where the petition is allowed to be filed by any third party? In that event, what may happen, my lord, for the single accused person, anybody, any close friend, any relatives, they may file applications in multiple courts, and they may file various applications pertaining to the same accused persons. That might create conflict. Therefore, it is important in ends of justice, my lord, that the petition is preferred by the accused. At least the petition is signed by the accused, so that accused is aware who is preferring the petitions, and whether any, so that even subsequently if any application is filed, he can inform that earlier applications also has been filed. But in absence of any provision where the accused is made to sign the petition, and people of their own, they can go and approach the court and file applications on behalf of the accused person. Accused is totally unaware of any application that is being filed in the court of law, my lord, and how many applications that has been filed, and this might create confusions and difficulty even for the accused persons. It is not only the bail application, they may prefer some other applications too. So this creates problem, and therefore it is important that for ends of justice, my lord, at least accused is made to sign the petition, my lord. That is what my submission will be, my lord.
I think that would be the natural assumption at this point, right? Sans any legal provision. But even so, what have you stated in your affidavit?
Gotcha. It would be at page number 11, Your Lordship. And the wife of the accused and this instant application is the first bail application be filed before the Honorable Court, and there is no other bail application pending with regards to the accused persons.
Have you stated that you have been authorized by?
No, that particular line is not present in the affidavit.
That would have been sufficient.
I understand.
Because you see, a statement of that kind in an affidavit would carry weight.
Right.
Because if found untrue, then you're liable.
Absolutely.
It is a fact, then it remains.
In this scenario, of course, we have discussed into this issue for quite some time. You're saying it is not permissible. I'm saying it is in the absence of any specific rules. But as suggested by Your Lordship, if you permit me to withdraw and get it signed by the accused and file a fresh application, I'm happy to do that also. As you had suggested earlier, just some time back. So then at least this primary issue would also be solved. We can go into the merits of the case also.
We can directly go to the merit of
But what you said is also correct. You see,
Some point of time,
you see what you have stated earlier is also correct. See, one way or the other, if not today, tomorrow, this
has to
issue
be decided,
has to be.
as and when the issue is raised.
It would have been better for a judicial pronouncement in this regard to be delivered.
So in this particular thing, if it is to be dealt with, it would also be necessary, I believe, to make the registry a party. I don't know, perhaps, because they also deal with the rules.
You cannot do that.
No, it can be taken up in some other separate proceeding.
Can be reference can be made.
Once order is passed, it is binding.
Reference can be made. You will refer to certain rules of the High Court. How can you make?
Because this is no, Lordship, what I'm saying, because this particular matter, this particular point is also larger. It carries a lot of weight. So perhaps a few more parties would have to be included in this. Maybe even the registry. Perhaps the registry.
I do not think registry will be required in this case because
the rules.
Once the order is passed, it is binding.
Again, I've said this enough. Reference to the rules may be made. That's all.
No, I'm just talking about deciding this particular matter separately in case that is to be done. That in case
that is a different issue.
That is a different matter.
That is different. If it is to be dealt with at the administrative level, as far as relevant rules are concerned, henceforth. That's a different thing.
Absolutely.
But we are talking about a judicial pronouncement.
Then they won't be required, of course.
Since this is a very, it appears to be, very vague.
Well.
Anyway.
As suggested, Lordship, I'll get it signed by the accused and file a fresh one. Absolutely the same application.
In course of hearing, Mr. S. Yadav, learned counsel for the petitioner, has submitted that the petitioner may be allowed to withdraw this petition with liberty to file a fresh one. Mr. N. Sinkon, learned GA, appearing for the state respondent, has no objection to the prayer made. Without going to the merits of the case, this court is inclined to allow the prayer of the learned counsel for the petitioner. Accordingly, this petition is hereby dismissed as withdrawn with liberty sought for allowed.
So need be mentioned as to why it has been.
No, not necessary to go into that. Then that would be entering into the merits.
Merits.
Obliged.
Second call from supplementary list, item number 1.
Your Lordship, I apologize. First of all, actually, I stuck in the traffic, so I could not. Your Lordship, this application is filed under section 482 by the petitioner, Your Lordship, as an anticipatory bail application, Your Lordship. Your Lordship, petitioner is a resident of village Rajapada, Your Lordship, and Lower Rajapada, PS Raniko, District Southwest Kashmir, Your Lordship. Your Lordship, in this case, I want to bring into the notice of this Honorable Court that this petitioner's father, he has received a notice under section 94 of the BNSS Act from the police, actually, Your Lordship. So this is notice dated 4/7/2025. It is Annexure 4, my lord.
Annexure?
Annexure 4. Page number 12, my lord.
Oh, Annexure 4.
Yes, Annexure 4, my lord. So this is consequent upon the FIR filed by the police, Your Lordship, who is called. So this is FIR is page number 13, my lord. So I want to go to the FIR only, page number 13, Your Lordship. So this is the FIR to the officer in charge. May I read, Your Lordship? To the officer in charge, police checkpost Gomaghat, Southwest Kashmir district, lodging an FIR against Sri Aribul Areng for appearance of documents from Lower Rajapada village in order to verification support for application scheduled tribe certificate from the office of the subdivisional officer, Circle Ranikor subdivision, Southwest Khasil district, your lordship. So FIR is the sir with reference to the subject cited above on behalf of the local community of Lower Rajapada village. I, the undersigned Sri Samuel Marak, the village headman, on receiving your letter number so and so Ranikor dated 3rd June 2025, have the honor to bring your kind notice before you for your kind information and necessary action. The sir, madam, as named, Sri Aribul Areng, son of Sri Rana Ahmed and Srimati Giti Areng of Lower Rajapada, as stated, is totally out of knowledge of the community of Lower Rajapada village. In this regard, with the decision of locality member, I would like to inform and request your office for taking necessary steps of action. Number one, Sri Aribul Areng is not from Lower Rajapada village, as rumored. He might be from Bangladesh. So first he is written, your lordship, that he might be from Bangladesh. Second one, he should be punished in accordance with law for betraying our local Lower Rajapada village that he belongs to. Before considering his father and mother to Sri Rana Ahmed and Sri Mati Griti Areng, he might be resided somewhere in Assam. So he might be having the NRC documents from the Assam government that he should be also produced for proof. His Aadhaar card, PAN card should be checked as from which document is required. He is appeared. With this information, I would like to inform and request you to kindly do the immediate arrest to Sri Aribul Areng. He is not known to the community of Lower Rajapada village. Your lordship, after receiving this notice, thereafter he received this notice, then the mother of the petitioner has appeared before the PS, and she has submitted the birth certificate, which is, your lordship, annexure 1 and 2, page number 9 and 10, your lordship. Page number 9 is the birth certificate, your lordship. So his name is there, your lordship. His date of birth is 15/2/2007. It is mentioned there. Name of the mother Griti Areng, name of father Rana Ahmed, and his address is Lower Rajapada village, Southwest Khashi Hills, 1904. Remarks if any. And your lordship is go to the page 10, your lordship. This is the lower primary certificate, your lordship. Page number 10. So this is a transfer certificate dated 16/2/2016, your lordship. Certified that Aribul Areng, son of Rana Ahmed, an inhabitant of Lower Rajapada, left the school on 15/12/2015. His date of birth, according to the admission register, was 15/2/2007. Was reading in class 4 and passed the examination for promotion in class 5 in 2016. So he has taken the certificate from there. Thereafter, what he has done, your lordship, he went to Assam for some purpose, actually in a boarding school. So from there he passed out actually HSLC examination. This is in the last year, your lordship. This year only HSLC mark sheet is annexed here as annexure 3, your lordship. So this is page number 11. This is from the Board of Assam School Board Education Board Division 1, Bamunimidam, Guwahati 1. And now at present, your lordship, his name is, everything is recorded there, your lordship. From the Royal Higher Secondary School he has passed. So now he is also studying class 11 at there. So this is actually a misunderstanding maybe from the side of the this headman, the complainant, because he does not know much about this person, because he was from after class 4 he shifted to the Assam Hailakandi and he's studying still there only. So all these documents are here, but still they are actually pressurizing that to surrender before the police, your lordship. So my prayer is that actually this is a genuine case. He is a citizen of India, and moreover there is a threat of arrest.
Where is this notice? Notice section under section 94 speaks of what?
This under 64 to appear before the PS only, your lordship. For clarifying all these documents, they have stated here original marriage certificate Rana Ahmed and Kriti Areng.
When are you called upon to appear? On
this is dated, your lordship, 4/7/2025, and they appeared on 6th, I think, your lordship.
They appeared on 6th?
Yes.
So they have appeared?
Appeared.
I mean, he has appeared?
Yeah, he has. No, not he himself. His mother and father both appeared.
Yes, because
Yes.
Notice was issued to his father.
Father, yes.
The father must have appeared.
Father was
Where is the any indication that he has appeared?
It is not here, but they have appeared, they stated. As the petitioner stated, they have appeared, Your Lordship.
And what is the opinion of the police?
Police still, they are actually pressurizing for surrendering him, the petitioner, before them. I don't know.
This has got nothing to do with with apprehension. Nothing to do with apprehension of arrest, because it is, you are just called to produce some documents,
Yes.
which you have done so.
Yes.
It doesn't say that if you cannot produce those documents, you will be arrested.
Yes, Your Lordship.
It doesn't say so.
Yes. But
Whatever course of action the police take, that's a different thing.
Yes.
But as far as this provision is concerned, so you are saying that you are apprehending arrest on behalf on the basis of this notice.
Still they are pressurizing, Your Lordship, to the father of the petitioner that he has to be surrendered before the police. That is the thing. That is their
Who has that, said that?
police
You have
intelligence.
to get a report from the IO then. Yes.
May it please your lordship. Lordship, as your lordship has correctly pointed out, lordship, the notice under section 94 of BNSS, lordship, has not even stated that he is subject to any form of intention, I mean like intent of arrest, lordship. It's just for the production of the papers. Lordship, this apprehension that is before this honorable court right now is premature, lordship. It has no foundation at all. So on what grounds, my lord, have they approached this honorable court? We are also unaware, lordship, because there's no whisper of any intent of arrest, my lord, anywhere in the petition.
In the petition it is there.
No, this paragraph 6.
My lord?
Paragraph 6. He has referred to this case registered as Rani Court PS case.
Lordship?
Yes, Your
This
is on the basis of that complaint made by that
headman. The complaint made by the local headman, lordship.
Yes.
Yes, my lord. But lordship, after the complaint was made, the steps taken by the police was just to seek documentation from the father of the accused person, my lord. That is the only step that the police have taken.
See, it is not even a notice under section 35.
It's under 94, my lord.
No, if a notice under section 35, is it 35 that speaks of appearance before the no 35. Section 35C, section 35 subsection 3. It speaks of a notice issued by the IO calling upon any person to appear before him. This is paramateria with section 41A. So if a notice of this sort or this kind has been issued upon you,
yes,
then you are required to appear.
Yes.
even then, that would not entail, arrest. If the IO on his investigation or on your statement or whatever feels that you are liable to be arrested, then he will file a report to the magistrate. Magistrate will pass the order, and you are likely to be arrested.
Yes.
But that situation has not come here.
The thing is that only my apprehension is that, your lordship, I'm a student and I'm studying. So if they detain me, that is my. And whatever the verbal actually discussion between petitioner's father and the police, so they are pressurizing that. That is
Let the IO file the status report.
Lordship.
As far as this case is concerned.
My lord, but nevertheless, lordship, there's no foundation. I mean, there's no basis on which this instant petition has been actually come before this honourable court, lordship.
See, but he is apparently, the FIR was filed on the basis of a complaint made against him.
And moreover, it is
against the petitioner.
Your lordship, moreover, it is a very different allegation, that is a foreigner's allegation. So then and there, actually, that is the thing.
Allegation can be
why he has filed, I do not know, but
anything.
It will be clear.
How old are you?
19 years, your lordship.
19.
Yes.
What, Mr. Chaudhary, learned counsel for the petitioner who has submitted that. The petitioner is a student who had passed out from Royal Higher Secondary School.
Yes, your lordship.
Royal Higher Secondary School.
No, this is Royal High School earlier. Now it is Royal Higher Secondary School, your lordship.
Royal High School.
Marksheet, yes. Royal High School, it is there.
Royal High School, Hailakandi.
Hailakandi, yes, your lordship.
Hailakandi District, Assam. Having passed his HSLC examination in the year this year. The Learned Council has also submitted that a complaint was filed before the officer in charge, Ranikor Police Station, Southwest Khas Hills, by one Shri Samuel Marak, Headman, Rajapara Village. The complaint concerned the issuance of the prayer for issuance of scheduled tribe certificate in favor of the petitioner, where the bona fide of the petitioner as a citizen of India has been questioned. Eventually, the said complaint was registered by the police as Ranikor PS case number 10 of 2025 under section 14 under bracket C of the Foreigners Act. In the meantime, notice under section 94 of the BNSS was issued upon the father of the petitioner, calling upon him to produce certain documents, which was done so on 6/7/2025. However, the Learned Council the Learned Council has submitted that in spite of such developments, it is learned that the police are seeking the arrest of the petitioner. Hence, on this apprehension of imminent arrest, the petitioner has approached this court with a prayer for grant of pre-arrest bail. Next, Mr. Gisela Laret, Senior G, appearing for the state for the respondents, has submitted that firstly, as regard the notice under section 94, the same was issued to the father of the petitioner, and even so, the provision of section 94 does not provide or empower the police to arrest the noticee, even if the noticee failed to comply with the said summon. Therefore, under such circumstances, there is no apprehension apparent to enable the petitioner to seek recourse from this court as far as the prayer made herein is concerned. It is prayed that necessary orders may be passed in this regard. This court has considered these submissions made and submission made, and its attention is drawn to the affirmation made at para 6 of this petition, which, as submitted by the Learned Counsel for the petitioner, refers to the institution, the registration of the Rani Court PS case numbers 10 of 2025. Apparently, the petitioner, being the focus of the complaint made therein, made in this said FIR, it is not known as to how the investigation has progressed and what is the findings or opinion of the IO at this point of time. Accordingly, it is at this juncture, it would be prudent for this court to call for the status report from the IO, more particularly as regard any action sought to be taken against the petitioner. Accordingly, as such, the IO is directed to file his status report on the next date fix. In the meantime, interim bail is granted to the petitioner in the event of his arrest, with condition that he shall not abscond and shall cooperate with the IO as and when required. How long can you?
1 week, my lord.
1 week. Can we fix a date?
Lordship.
Which
At the
date?
convenience of this honorable court, my lord.
Today is 6. 14.
My lord.
As prayed to list this matter on 14.
Much obliged, lordship.
Hello.
Item number 2.
My lord.
Yes. Where were we?
My lord had referred to another judgment yesterday.
Oh, okay.
My lord, 2012 matter. I don't have a copy of this. My lord. My lord, this is a judgment where the court had refused. My lord, yesterday I had taken my lord through 3 judgments. I had supplied a compilation also, my lord. My lord, in that compilation, primarily first we had gone through 2002 4 SCC 578 P. Ramachandra Rao, which had flown down from my lord. My lord, going through the judgment, one thing which was made, which had come out clearly, was that it has gone on to uphold the ratio and the law as laid down in Antule's judgment, my lord. My lord. My lord, it was also seen that in P. Ramachandra Rao, the 4 judgments which were passed over a period of time, the Rajdeo judgments and the common cause judgment 1 and 2, Rajdeo 1 and 2, where a fixed time limit was prescribed with regards to certain categorization of cases. The cases which are punishable up to 3 years, up to 1 year, non-cognizable offences, certain classification of these cases were made and a fixed time limit was prescribed. So the court said that under the Code of Criminal Procedure, there is no fixed time limit which is prescribed for completion of a trial. Yes, for certain category of offences, CRPC prescribed a time limit for taking cognizance of the offences or making a complaint.
That principle has, is still running its course.
My lord. So
where no time, specific time limit can be fixed.
My lord.
As far as completion of trials.
My lord, agree. Absolutely, my lord.
But
my lord,
then the other aspect of the matter.
The other aspects. Now, P. Ramachandra Rao had upheld the certain guidelines which were given in Antule's judgment, my lord, where it was identified that the right of speedy trial is one which is enshrined under the Constitution of India under Article 21 and is absolutely available for the accused who's facing a trial, my lord. My lord, the judgment also said that in case of a delay in trial, the High Court can exercise its power under 482 then, 528 now, to quash the proceedings and also exercise its power under 226 or 227 of the Constitution, as the case may be, to quash the proceedings. However, every case has to be seen independently, my lord. The judgment also goes on to say that it is not necessary that every time the matter has to be quashed. The High Court can also exercise its jurisdiction to pass directions for the trial to proceed speedily. Now, while saying that, the judgments, the law as laid down also goes on to say, my lord, that under 309 of the CRPC, it is expected of the trial court to conduct a trial on day-to-day basis, unless for certain exceptional circumstances, my lord, the court has to adjourn the matter beyond a period of 1 day. But, my lord, nowhere it says that the adjournments have to be mechanical, my lord, for 3 weeks, 4 weeks, 2 weeks. If the accused is in custody, normally they are for 14 days. If they are out, normally they are of 30 days and beyond. So, my lord, the ratio as laid down also goes on to say that the conduct of the parties in the trial has to be seen. Now, my lord, that brings me to my final leg of the argument on the points of law here, my lord. My lord, post that, my lord, we had seen the last judgment as had been placed by me, my lord, yesterday, Pankaj Kumar versus State of Maharashtra. And, my lord, therein we had, due to constraint of time, my lord, we had to wait. My lord had to rise up, my lord. For that, my lord, if we could refer to para 18 at page 125, my lord, internal page, my lord, of the compilation.
Yes.
Page 125, internal page
Yes.
94, my lord.
Para 18. Yes.
Para 18, if I may, my lord.
Please.
The exposition of Article 21 in Husnaira Khatun's case was exhaustively considered afresh by the Constitution Bench in Abdul Rahman Antule versus R.S. Nayak, referring to a number of decisions of this court and the American precedents on the 6th Amendment of their Constitution, making the right to a speedy and public trial a constitutional guarantee. The court formulated as many as 11 propositions with a note of caution that these were not exhaustive and were meant only to serve the guidelines. For the sake of brevity, we do not propose to reproduce all the said propositions, and it would suffice to note that the gist thereof. These are: 1. Fair, just and reasonable procedure and implicit in Article 21 of the Constitution creates a right in the accused to be tried speedily. 2. The right of speedy trial flowing from Article 21 encompasses all the stages, namely the stage of investigation, inquiry, trial, appeal, revision and retrial. 3. In every case where the speedy trial is alleged to have been infringed, the first question to be put and answered is, who is responsible for the delay? While determining whether undue delay has occurred, resulting in violation of right to speedy trial, one must have good regard to all the attendant circumstances, including the nature of offence, the number of accused, and the witnesses, the workload of the court concerned, prevailing local conditions, and so on. What is called the systematic delays. 5. Each and every delay does not necessarily prejudice the accused. Some delays may indeed work to his advantage. However, inordinately long delay may be taken as presumptive proof of prejudice. In this context, the fact of incarceration of the accused will be a relevant fact. The prosecution should not be allowed to become a persecution. But when does the prosecution become persecution again depends upon the facts of a given case. Ultimately, the court has to balance and weigh several factors, balancing test or balancing process, and determine in each case whether the right to speedy trial has been denied. 8. Ordinarily speaking, where the court comes to the conclusion that the right to speedy trial of an accused has been infringed, the charges or the conviction, as the case may be, shall be quashed. But that is not the only course open, and having regard to the nature of the offence and other circumstances, when the court feels that quashing of the proceedings cannot be in the interest of justice, it is open to the court to make appropriate orders, including fixing the period for completion of trial. It is neither advisable nor feasible to prescribe any outer limit for conclusion of all criminal proceedings. In every case of complaint of denial of right to speedy trial, it is primarily for the prosecution to justify and explain the delay. At the same time, it is the duty of the court to weigh all the circumstances of a given case before pronouncing upon the complaint. An objection based on denial of right to speedy trial and for relief on that account should first be addressed to the High Court. Even if the High Court entertains such a plea, ordinarily it should not stay the proceedings except in a case of grave exceptional nature. Such proceedings in the High Court must, however, be disposed of on a priority basis. My lord, at entry 8, it very categorically has made the court says, my lord, I'll come back to it, my lord. If para 19 is where the interpretation of Antule and P. Ramachandra Rao has been done by the apex court, my lord, I'll just go through para 19, 20 short paragraphs. Notwithstanding elaborate enunciation of Article 21 of the Constitution and Abdul Rahman Antule and rejection of the fervent plea of proponents of the right to speedy trial, laying down time limits as bar beyond which a criminal trial shall not proceed, pronouncements of this court in Common Cause, a registered society versus Union of India, Common Cause, a registered society versus Union of India, Rajdiyo Sharma versus State of Bihar and Rajdiyo Sharma 2 versus State of Bihar, gave rise to some confusion on the question whether an outer limit for conclusion of criminal proceedings could be prescribed, whether the trial court would be obliged to terminate the proceedings and necessarily acquit or discharge the accused. The confusion on the issue was set at rest by a 7-judge bench of this court in P. Ramachandra Rao versus State of Karnataka. Speaking for the majority, R.C. Lahoti judge, as his lordship then was, while affirming the dictum in A.R. Antule's case, is correct and still holds the field and the propositions emerging from Article 21 of the Constitution and expounding the right to speedy trial laid down as guidelines in the case adequately take care of the right to speedy trial. It was held that guidelines laid down in A.R. Antule's case are not exhaustive but only illustrative. They do not intend to operate as hard and fast rules or to be applied in a straitjacket formula. Their applicability would depend on the fact situation of each case, as it is difficult to foresee all situations and no generalization can be made. It has also been held that it is neither advisable nor feasible nor judicially permissible to draw or prescribe an outer limit for conclusion of all criminal proceedings. Nevertheless, the criminal court should exercise their available powers, such as those under section 309, 311 and 258 CRPC, to effectuate the right to speedy trial. In appropriate cases, jurisdiction of the High Court under section 482 CRPC and articles 226 and 227 of the Constitution can be invoked, seeking appropriate relief or suitable directions. The outer limits or power of limitation expounded in the aforenoted judgments were held not to be in consonance with the legislative intent. My lord, in this particular case, the court goes on, after playing reliance on A.R. Antule and P. Srinivas Ramachandra Rao, to quash the proceedings. Now, my lord, this brings us to the last leg, my lord, of my legal submission. My lord, I have taken, my lord, through para 27 of this judgment, where the proceedings were quashed yesterday, my lord. If I may, my lord?
Yes.
Be that as it may, the prosecution has failed to show any exceptional circumstances which could possibly be taken into consideration for condoning the prolongation of investigation and the trial. The lackadaisical manner of investigation spread over a period of 4 years in a case of this type, an inordinate delay of over 8 years, excluding the period when the record of the trial court was then the High Court, is manifestly clear. Thus, on facts in hand, we are convinced that the appellant has been denied his valuable constitutional right to a speedy investigation and trial, and therefore criminal proceedings initiated against him in the year 1987 and pending in the court of the Special Judge Latour deserve to be quashed on this short ground alone. Now, my lord, there was another judgment which had flown down from my lord yesterday towards the concluding parts of the argument, my lord. This is the one, gentlemen. My lord, 2012 8 SCC 495, my lord. Now, my lord, I admit that in this case, the court again, while placing reliance on A.R. Antule, as well as, my lord, on P. Ramachandra Rao, had dismissed this petition by disallowing the prayer for quashing, my lord. Now, my lord, the reason for that, we will find it mentioned, my lord, at para 26, my lord, page 513, as to why it was done. If I may, my lord?
Yes.
Para 26, page 513. In view of the settled position of law and particularly in the facts of the present case, we are not in agreement with the submissions made by the learned senior counsel Shri So-and-so. Before we conclude, we intend to say, particularly looking into long adjournments sought by the accused persons who are 7 in number, that the accused cannot take advantage or the benefit of the right of speedy trial by causing the delay and then use that delay in order to assert their rights. My lord, the only difference between Pankaj Kumar versus State of Maharashtra 2008 16 SCC 117 and my lord Ranjan Devi 2012 8 SCC 495 is that, my lord, the proceedings were quashed because the delay was on part of the prosecution and prosecution could not satisfactorily explain those delays. Now, my lord, in this particular judgment of 2012, the proceedings were not quashed because there was inordinate delay on part of the accused, who was 7 in number, and over a period of time, someone or the other was constantly seeking adjournment, which clubbed together culminate to become a long adjournment. Now, my lord, it is also not my case that I have never sought an adjournment in this trial, my lord. The trial has been pending since 2009, charges framed in 2012, we stand in 2025. But, my lord, if we see the reasons for delay, the facts on which, my lord, I'll take, my lord, to the factual aspect of my argument, bringing to my case. Now, my lord, on an overview, there have been several instances when the prosecutor is not present. Now, the reason being is, there are times when the prosecutors have changed constantly for CBI. The new appointment of prosecutors are awaited. We have annexed those orders. My lord, this is a murder case. It is their case that the murder weapon is a knife. There have been occasions when they cannot even find that knife. There have been occasions when they do not find the lock, the key to the lock in which the box of which they keep their exhibits. My lord, there have been times when they are unable to secure the attendance of their witnesses and produce them. My lord, there have been times when the court had to go to the extent of issue arrest warrants to the witnesses to call them. So, my lord, these are delays which are attributable to them. Now, my lord, I am 75 years of age. I was in service when this case was initiated against me. My lord, I was at the helm and prime of my career. It is not the case of them that I aided or assisted in the alleged offence. My lord, I am at the fag end of my career, of my life now. I have crossed 75 years of age. I have crossed the average life expectancy of this, as has been formulated by the Ministry of Health in India, my lord. My defense witnesses, my lord, if any I would have, we cannot assume and presume I don't have, depending on the case they have placed, my lord. It is, on a very practical note, my lord, my witnesses will start expiring now. My wife is bedridden, she is crippled. My lord, the trial has been going on. My lord, if we just see the pace of the trial at page 12 of my petition, my lord. We have taken the liberty of providing a pie diagram to it. My lord will see the trial commenced in 2009. My lord, charge sheet was filed. Charges framed in 2012. So page 12, my lord, 2009, no witness, 10 no witness, 11 no witness, 12 9, 13 12, 14 0 witness, 15 2 witness, 16 6, 17 1, 18 2, 19 1, 2021 witness, 2021 0, 22 8, 23 10, 24 3, 25 2 witnesses. During the pendency of this petition, my lord, another witness has been examined. Now, if my lord is of the view, I will produce the evidence of that witness. This witness supposedly was a witness.
How many witnesses are there altogether?
110, my lord.
110.
As per their charge sheet, there are 110 witnesses, my lord. 102. My lord, I have mentioned 102, but as per the 102, my lord.
Okay, so only 57?
58 have been completed, my lord. My lord, I don't want to go to the grave as an under trial.
Was convict.
Once you are in
yeah, as an under, no, that is what, either convict me or acquit me, but give me a verdict. Don't send me to the grave as an under trial.
Once you are in the grave, you are under.
No, but I don't want to reach that grave as an under trial. My lord, it's a humiliation.
You see, I think we have to
balance the equity, my lord.
We have to approach this, this issue, pragmatically.
My lord,
I'll submit only two things. Very, very short submission I have, my lord. My lord, he's seeking quashing on the ground of delay. So my first submission is, my lord, is not that kind of delay which will warrant some kind of quashing, my lord, in the present case. Because, my lord, my friend has annexed the chart. 20, 21, 19, my lord, 20, these are the COVID periods, my lord. So we can safely exclude these two periods, my lord. At page 13 of the petition, my lord. And then charges were framed only in 2012, my lord. So in 10 years, if 50, my lord, so my lord, in my humble submission, this is not such a delay, my lord, on the part of prosecution that will warrant some kind of quashing. Second aspect, my lord, he is co-accused. The main accused is Mr. A.C. Sangma. He is charged with 302. The present petitioner is only charged with 201, my lord, for causing disappearance of evidence. So, quashing a case against him, my lord, will seriously prejudice the case against A1. That is our submission, my lord. Had it been a sole accused, my lord, maybe the considerations may be different, my lord. But when there are co-accused, and he is a subsidiary accused, my lord. So discharging a case or quashing the case charges against him, my lord, we will cause seriously prejudice the trial.
If suppose we just in supposition now,
my lord,
if the case is discharged against him, how would that prejudice the cause of the prosecution as far as the main accused is concerned?
My lord,
Because
all
as far
these
as charges against or accusation against the main accused is concerned, is under 302. So the consideration would be, different and separate. But as far as he is concerned, it's only under 201. So even the punishment would be.
So, my lord, because we do not know, my lord, the witnesses are yet to be examined. What will be the consequence of that? We are not able, really in a position to say right now. But, my lord, in an array of the series of decisions, what the Supreme Court has said, my lord, right to speedy trial, my lord. My friend has placed judgment also. That some kind of time frame may be fixed, my lord. But it's not a case for quashing, my lord. That's in my humble submission, my lord.
This court will be want to to pass such a dictum because it's against the.
To expedite the trial, my lord, in my humble submission, that is only really possible.
The only direction that can be given is to request the trial court to expedite the trial.
My lord.
Take recourse to, as I said the other day, take recourse to 309.
My lord.
And then try to, but no time frame.
And also, I advise the department also to examine whether the list of witnesses can be
Exactly. That's what I was about to say.
My lord, I don't. Sir, may one submission?
No,
because you see, if you whittle the size of the prosecution witnesses, that may help them.
The department may be directed to examine that. If they can cut short the list, my lord, by some witnesses at least, which are not so vital to the case, my lord, they'll examine it there and, my lord, because it is for them. They are the prosecutor. They'll know what the important witnesses and which can be dispensed with, my lord.
True.
So that's one aspect, my lord. And in my humble submission, my lord, that is the only direction, and that will do. Address his grievances also, my lord, rather than going for questioning.
Mr. Kher, I think as far as this involves a murder case. You as Dr. Murziga has said, as far as charges against you is concerned, it may be 201, but it's not 320 against you.
201, 203.
Exactly. But then you see, there is also the main accused to be to be taken care of.
My lord.
So it may have a corresponding effect, taking the case in its totality. At the most,
I'm not going to the merits of the matter at this stage, my lord, because it is of no use. But, my lord, the charge sheet that has been filed, my lord, there are repetitive witnesses, and the 161 statement, it's naked eye says.
That is not as Dr. Murziga said. It's for he will advise the
my lord
department or.
My lord, recently Madras High Court, my lord, I have not placed the judgment as yet, but I'm in possession. I can place it if required. My lord, they have imposed a cost of 1 lakh rupees on prosecution. No, that is, I'm not seeking it, but I'm just bringing it, my lords, to the forum that courts have now started to go proactive on these kind of issues, my lord, for prolonged delay. So, my lord, I don't seek a permanent time frame because that will be against the settled tenets and principle of law. Though Antule and Ramachandra Rao says that yes, in certain circumstances, if the court is of the opinion that no, seeing the nature of the offence, there cannot be a fixed time limit and cannot quash it, so a time limit can be set.
Rather than a fixed time limit, my lord,
no, I'm not
to expedite, my lord, and preferably maybe within 1 year's time or 2 years' time.
I am not going for a time limit, but my lord, I'm duty bound to place one thing. Even if it goes on a weekly basis from today, it is going to take at least 75 weeks to complete the trial. And on a weekly basis only.
Not sir, 48 only 48.
You're still missing the point.
My lord.
Dr. Murziga has advanced his argument, or rather his submission, conceding to the fact that he will advise the department accordingly, or whoever is the prosecution, to whittle down the number of or the list of witnesses. From let's say there are another 50 witnesses available, 40 or 50, whatever. If it can be, cut short to about 20,
30, 25,
20, 25, whatever. And then that's number one. Number two is we would request the court to take up the case on a day-to-day basis.
My lord.
Then even then, you see, then the time period would be cut short.
My lord.
So that would serve your purpose.
My lord. It does.
So I think that's the only direction that could be given at this point of time.
Well, and that will be fair for both the
Because
parties also.
you have to understand
It's fair, my lord.
what he said. So, keeping in mind his his age.
Yes. But that was the reason, my lord, to be fair to him also, my lord, I submitted in that direction, my lord. My lord, only one thing, lordship can give a direction to CBI to examine if the list of witness can be
Yes,
taken.
that can be done. That can be done. Though we cannot
And to expedite the trial.
curtail their rights, but then
They can to examine and if possible to cut short, to facilitate expeditious trial.
My lord, I totally agree and follow to the lead taken by the learned senior here. And
so in that case, a very detailed judgment may not be necessary.
not
Not required, my lord.
I'll see.
Or you want a detailed judgment?
good judgment, my lord, detailed. Short is.
I would.
If it was to be reported, my lord, then the thing is different.
I would like to set a record by passing a one paragraph judgment, but that's not possible.
My lord.
He wants it to be in live law tomorrow, my lord.
My lord, I don't want a detail or a short. I want a good judgment. My lord, I believe the laws that have been placed, if they are reflected in the judgment, it will be a guidance for the future trials, my lord, if any are stuck in holes like this.
Heard Mr. Nkera, learned counsel for the petitioner. Also heard Dr. N. Muzika, learned TSGI, appearing for the respondent, CBI. A short question of law and facts is required to be decided in this case. It is a credit to the expertise of the learned counsels who has made the endeavor to advance their submission at this stage of the proceedings, and for the matter to be concluded at the first hearing itself. It is the case of the petitioner that he is involved as an accused in, what's the case number?
My lord, session 76T of 2013.
In
sessions case 76.
Sessions case number 776 under bracket T of 2013, pending trial before the court of the learned additional district and sessions judge, Shillong. Apparently, the trial has taken
16 years.
16 years. It's taken about 16 years till date, and is.
But 16 years will not be correct, my lord. Charges framed in 2012.
13 to.
Charge sheet filed in 2009.
We are
Charges
not,
framed in 12.
you have to take it only from the date when the charges are framed.
Charges are
Why
framed.
not? 13 years completed.
So 13 years.
Yes.
13 years.
12.
Should be 12.
Yes.
We're taking the year as 2013.
Yes. 13, not 16 years, but 13 years.
My lord.
That also almost 2.5 years COVID.
COVID. You have still managed to examine some witnesses during COVID.
During that period,
except,
only one.
except 2021.
20 is 0, my lord. 21 is 0.
21 is 0, but 20 is 1, 19 is 1.
Yes.
Kan untuk mau? 12 years or so. And this has troubled the petitioner, who has submitted that being of advanced age, nearing of about 70 years, 75 years or so, and being diligent in his appearance before the court all along, the manner in which the trial has proceeded has caused concern to the petitioner as to when the trial would be finally over, given the fact that there are altogether 102 witnesses, of which 58 of them have been examined and discharged so far. If the natural course of the trial is expected to be conducted, it would take another 75 weeks or so for the trial to be completed. Next, it is on this sole ground that the petitioner has now approached this court with the prayer inter alia that they would pray inter alia, that with a prayer that the case against the petitioner be quashed, as the same has resulted in, as continuance of the same has resulted in a violation of the petitioner's fundamental rights. On a query made by this court, the learned counsel for the petitioner has referred to the authority in the case of ER Antule versus RS Nayak, reported in 1992, 1 SEC 225, followed by the case of P. Ramachandra Rao versus State of Karnataka, 2002, 4 SEC 578. And finally, reference is also made to the case of Pankaj Kumar versus State of Maharashtra, 2008, 16 SEC 117. What are the paragraphs you have relied upon in the case of Antule? The case of Antule, AR Antule? What are the paragraphs you have relied upon? there are certain paragraphs you have referred to.
Para 81.
Para 81.
Para 81, 84, 81, 82, 84. My lord, the guidelines actually contain are in 86, my lord, which sums up the issue. 81 and 86, my lord. 81 talks about Menika Gandhi in Article 21, and 86 are the guidelines, my lord. Internal page.
Yes.
76 would be para 86 with the guidelines. My lord, internal page 73.
Yes.
17.
Yes. 73. It was.
My lord, 73 is para 81, article 21, my lord.
Wherein, Kunutumo? Wherein at AR to legal I will you come with the next one I wherein in the case of AR Antuli at para 18 of the same, the apex court has emphasized on the importance of application of the provision of Article 21 vis-a-vis the deprivation of life and liberty of a person undergoing trial in a criminal case, to say that such a person has a right to be tried speedily, which means that he has a right that speedy trial is a right available to a person undergoing trial in a criminal case. The principle formulated by the apex court in this case have been crystallized and laid down at para 86. Which is reproduced here in below. Next, it is also the submission of the learned counsel that the apex court in the case of P. Ramachandra Rao Supra has reiterated the principle laid down in the case of A.R. Antuli as far as the issue of rights and liberty of a person undergoing trial in a criminal case is concerned, particularly with reference to a speedy trial in that respect.
My lord, para 29.
Page?
My lord, internal page 26, para 29, my lord.
para 29 of the said judgment is a reiteration of the court the principle laid down by the laid down in the case of E.R. Antuli Supra. However, the Land Council has also referred to the case of Pankaj Kumar, wherein the Apex Court, taking note of the proposition of law in the case of E.R. Antuli and P. Ramachandra, has, however, emphasized the fact that speedy trial is a must and has to be resorted to has to be resorted to, comma, the delay as far as speedy trial is concerned has to be pinpoint and attributed to certain factors, comma, for example, the conduct of the parties, etc. Though the court at para 18 of the said judgment has also opined that I quote more, it is open to the court to make appropriate orders, comma, including fixing the period of completion of trial, semicolon, I 8 and bracket 8 Roman 8 more. It is neither advisable nor feasible to prescribe any outer time limit for conclusion of all criminal proceedings. Close. The learned counsel has, however, fairly submitted that at this stage, quashing of the proceeding against the petitioner would not be insisted. Nevertheless, it is prayed that this court may be pleased to issue necessary direction for the trial court to expedite the proceedings to ensure that the petitioner is not faced to unnecessary delay as far as the same is concerned, as far as this trial is concerned. Dr. N. Musiga, let us see. You appear as CGSI? SG or CG? TSGI has also stressed on the fact that apart from the severity of the offence for which the petitioner is undergoing trial, though not as the main accused, since the trial involved offences under section 302, comma 302 oblique 201 and 203
201, 203 IPC.
and 203 IPC. The sections of law implicated against the accused refers only to section 201 and 203 IPC. Be that as it may, the learned DSGI has submitted that it would not be proper for quashing of the proceedings against the petitioner, given the fact that there are only two accused, given the fact that there is another co-accused person involved who is facing trial, particularly against, particularly in facing trial for particularly for an offence under section 302. However, the learned DSGI has also fairly conceded that the prayer of the learned counsel for the petitioner for this court to pass necessary direction as regard the manner in which the trial is to proceed is found acceptable. Next. Under such circumstances, this court would not go further into any unnecessary discussion on the merits of this case and would dispose of the same with the following direction: that the learned trial court is requested to take up the proceedings expeditiously, recourse being had to the provision of section 309 CRPC. Two, that the prosecution be directed to revisit the list of witnesses cited and to cut down the list by striking off irrelevant or unnecessary witnesses. Anything else? 309, list of witnesses cut.
309 is elaborated in one sentence.
Yeah, day to day. What is it?
Whoever seeks.
High Court is aware of what she's doing.
Trial court.
My friend is doing the trial.
One observation. I don't want to come.
I said take recourse to 309.
309 can also be read exam for ground.
Okay.
Some observation is.
So heading to 309. Heading to taking recourse to the provision of section 309. Particularly to ensure that, if possible, the case is taken up on a day-to-day basis. I think that's all.
The second sentence, your lordship said to revisit the list of witnesses.
and cut down whatever is irrelevant or if any. That's what I said. I thought to if any. With the above direction, this petition is hereby disposed of. No cause. Huh?
My agreement has been recorded as if it will take 75 weeks to complete. But I have placed that even if it is taken up on a weekly basis, then 75 weeks.
Okay. Como tu, ngai hei puru. That's a submission, yes. It will be 75 weeks to complete. If the case is taken up on a weekly basis. Thank you. Why?
Lordship, I'm praying for 2 weeks accommodation, Your Lordship. Item 11, Your Lordship.
Why are you praying?
The senior counsel is having some personal difficulty, Your Lordship.
Premier by the appellant, this is matter up to 3 weeks.
Apply, Your Lord.
Lordship, in item 14, Your Lordship, I am mentioning on behalf of Mr. S. Thapa, Your Lordship.
14. 14.
14, Your Lordship.
Same order.
Same order. Your Lordship.
Please, Lordship. Lordship, I beg to mention item number 7.
I think.
Lordship, I paid for 2 weeks' time.
How many times have you asked for adjournment in this matter? Pleadings are complete.
Lordship, in this matter, we have to prepare the informal paper book and please grant us for the 2 weeks' time, Your Lordship.
On premier by the petitioner, this is matter up to 3 weeks.
Lordship, I also beg to mention item number 18. Lordship, I pray that this matter may come up next week, Your Lordship.
After?
Next week, Your Lordship.
Why? Why not today?
Lordship, in this matter, we have to produce the order for framing of charges, and we have applied for this, and we are yet to receive, Your Lordship.
Paper book prepared, isn't it?
No, Your Lordship. In this matter, we have to produce the order for framing of charges, Your Lordship.
This is a matter, my lord, criminal trial is pending, and disciplinary departmental proceedings are also pending.
No, we are talking about item. Oh, sorry,
18, Your Lordship.
yes. Disciplinary proceedings.
It was heard on last occasion, last week, I think. They went to CAT for staying the departmental proceedings, my lord, on the ground that same charges are there before the criminal trial also.
Okay.
So the CAT has dismissed the petition, my lord.
Oh,
Against that.
whether departmental proceeding can, proceed or.
So, well, the question was posed to them to show the charges. What are the charges in the
whether they
criminal
are
trial?
similar or. The law in this matter is settled. Two proceedings cannot proceed simultaneously.
My lord, the law is it says, my lord, it can proceed, my lord, depending on the facts.
It can, but
if the charges are identical and witnesses are
but
common,
his contention is that it will
10 witnesses are
prejudice his case, his defense.
That's what he's saying. But only 3 witnesses are left. Other witnesses have already been examined.
On pre-made by the petitioner, this is matter of 1 week.
And your pleasure.
May it please your lordship, I beg to mention item number 17, my lord. Kindly accommodate me for another 2 weeks, my lord, for preparation.
2 weeks.
Highly obliged, my lord.
Lordship, I beg to mention item number 9, Lordship. Lordship, if the matter can come up after 2 weeks, my lord.
No objection, lordship. On pre-made by Mr. S. Gupta, this is matter of 2 weeks. 9.
Deeply.
Lordship, I beg to mention also item number 12, my lord. Mr. Yogin is there. I had taken his consent earlier. Item number 12.
Weeks time, my lord.
2 weeks. 2 weeks.
My lord, 2 weeks. Obliged.
If Lordship pleases, I beg to mention item number 15 and 16 as well. Mr. Pandit was there.
I had requested him, my lord, to give them 15 and 16.
In 15, my lord, item number 15, we have come to learn that another accused who was also convicted in the same case, he has also filed an appeal, and that is criminal appeal number 11 of 2025. But that appeal is was listed before another division bench.
What is the stage of the case?
I think hearing only.
Hearing?
Yes. He has filed, I think, recently.
No, recently, that means
after me.
Everything, all formalities completed, paper book, everything finished.
Yes, I have completed my.
No, in the other case.
That I am not aware, but I just came to learn that. Yes, ma'am.
Then what is your ground?
No ground. Just I am informing to the honorable court that another is also there.
We'll see.
Otherwise, I have no objection.
We'll see as and when the matter comes up.
No, this is not listed before this bench.
Like this, let this matter come up, and you.
I'm not aware of it, Mr.
You find out and see.
Yes, we'll find out, my lord.
I have no objection.
How long?
2 weeks, my lord. Item number 16 as well, my lord.
15, 16?
Yes,
2 weeks.
16, my lord, I have filed one application also, misapplication.
Where?
For taking additional evidence. One
that we'll see.
At the time of hearing, my lord.
Supplementary list, item number 1.
My lords, my lord, the petitioner was selected, my lord, to the post of lab assistant at National Institute of Fashion. Page 22. And the advertisement, my lord will note, the advertisement was for a long-term contract basis. The appointment that was given to me, my lord, page 22, my lord will see subject. Appointment for the post of lab assistant at NIFT Shillong campus on short-term contract basis. Now there is an office memorandum, my lord, I'll just take the office memorandum. The office memorandum at page 25, my lord, just for a moment, my lord. Page 25 is the office memorandum. The office memorandum says, my lord, I permitted to read, my lord, on the recommendation made by the establishment committee in its meeting held on 08/01/2018, the Board of Governors of NIFT, in its meeting held on 15/02/2018, has approved the following. All recruitment at the base level shall be made on contract for a period of 5 years for providing enough time to the new employees to assimilate the spirit of the institution, failing which the institution shall have the right to terminate the services. Number 2, regularization of all employees shall be considered after 5 years with provision to review the performance every 2 years during contract period to guard against the developing complemency in functioning on roster 1, so and so, my lord. So now office memorandum says the long-term contract should be for 5 years. Thereafter, set to the satisfaction of the performance, and he will be entitled to even regularization also. And my lord has seen the advertisement. The advertisement was also issued for a long term. Long term would mean 5 years. Appointment was given to me for 6 months. Okay, so far, okay, but my lord, I was again and again appointed, my lord, renewed my services, my lord. My services was renewed from time to time, my lord. So I continue to work. Now what happened, my lord, when I was still serving in a contractual basis, an advertisement came up, my lord. The advertisement came up, and this advertisement calls for another contractual employee, which means, my lord, now I am already in a contract post. I have to be replaced by another contract. So my lord knows a contractual employee or an ad hoc employee cannot be replaced by another contractual employee if there is no adverse remark against the employee, my lord. So my lord, thereafter, my lord, I'll just skip few pages, my lord. This is just for the state of motion, therefore, my lord. I sought some clarification, my lord. I sought some clarification from NIFT. How come your advertisement, your policy, your office memorandum said is for 5 years, and I was given only for 6 months, and you have extended from time to time? Aggrieved by non-reply, my lord, I went to the CAT, my lord. I went to the CAT. CAT by page 38, my lord, CAT order dated 30th of May 2024, my lord. 30th of May 2024, dismiss my application, my lord. By holding that...
What was your prayer there?
My lord, my prayer was that I should be allowed to continue for 5 years because the advertisement and the office memorandum says so. So I should be allowed to continue.
Have you made any such representation before the authorities? Yeah, the first instance.
Yes. I've made a representation, my lord, by clarification, my lord, seeking clarification to the NIFT, my lord.
As far as the tenure is concerned.
Tenure is concerned, yes, my lord. I did so, my lord. So
where is that?
My lord, that is at page page 37, my lord. Page 37. That's on 10th February 2021, my lord. My lord has got page 37.
Yes.
Annexion 9. So, my lord,
it's okay. I can read it. My brother's copy is not so clear.
My lord,
even a clear copy, you see.
my lord, my lord, where's the previous one? My lord, I'll provide a
Please.
I'll just read, my lord. Subject: request for clarification on appointment as lab assistant F&L department on short-term contract. Respects, sir, with reference to the above mentioned subject, I would like to put forth my appeal with regard to my appointment as lab assistant so and so. Detail here below that I have applied for the post at NIFT Shillong by advertisement so and so, published in the local newspaper on such and such date. And as per instructions mentioned in the advertisement, the undersigned downloaded the application from so. That, sir, as per the advertisement, the recruitment was based on long-term contract basis with a payoff so and so as per 7th pay CPC of the government of India. The undersigned had gone through written test and skill test lab assistant, which was conducted on 21st May 2019 at 10 a.m. by the institution as per norms and was qualified for the post by receiving appointment letter. But upon receiving the appointment letter, it has been mentioned that I have been appointed on short-term basis and not on a long-term basis as per the advertisement. Thus, since the undersigned was not aware about the differences of short-term and long-term contract, I was in expectation that even though the appointment was on a short-term, the salary would be based on a pay scale. But upon receiving my first salary, it was noticed that the amount received was based on a pay scale but was given fixed salary so and so. That, sir, in view of the above, I have the honor to heartily request you to seek clarification with regard to my appointment as lab assistant as to why I was appointed on short-term contract basis instead of a long-term contract basis. So I sought this clarification, my lord. Having failed, my lord, to get proper response, my lord, I filed...
So this is the only representation you have filed?
This is only representations that I have filed, my
No
lord.
reminder or nothing.
No, nothing, my lord, nothing. So, my lord, then I filed the application before the CAT, my lord. Now, what I am aggrieved here with the CAT, my lord, I've pointed out the advertisement, my lord, two advertisements. The first advertisement through which I entered the service, my lord, and that was the same advertisement for a long-term contractual engagement. Another advertisement when my service was still in subsistence, another advertisement comes which also says that long-term contractual engagement, my lord. So I went to the court. The court did not look into that aspect, my lord. The court did not look into the aspect. The court only looked into the aspect that since you are a contractual employee, so by nature of a contractual employment, you know that you cannot be extended. Because I was asking, please, this is a long-term extended. Office memorandum says I should be appointed for 5 years. Thereafter, on the examination or re-evaluation of my performance and suitability, I should be allowed, I should get an opportunity to be regularized. Also, the office memorandum says so. But the CAT did overlook this aspect and only went to the extent say that since you have openly accepted contract, therefore your contractual in any way will coming to a 5 years term now by end. So therefore, we are not giving you any extension, my lord. Now, my lord, why?
See, you have been appointed in the year 2020.
2000? Yes, my lord.
That's next year 6.
Yes, my lord. 2019, I'm sorry, 2019, my lord.
2019.
Yes, my lord, 2019.
Now, 2019, you've continued. I mean, they may have, given you.
Yes.
You see, periodical extension. You said
yes, they gave me. Yes, my lord. My lord.
See, nevertheless, what happened is,
yes,
in due course.
Yes.
From 2019.
Yes.
Till today.
Yes.
That 5 years period must have been over.
Yes.
Till today. You were in continuous service then.
If I were in continuous service, if I were in continuous service, my lord, that period could have been over by now, my lord, if I was in continuous service. But my lord, the issue here, why I'm aggrieved here is, my lord, now another advertisement has come, my lord. Now another, and the first advertisement came while I was still in the service, which I was saying, but subsequently, my lord, that was withdrawn. Now another advertisement comes, my lord. Same advertisement is saying that they need a lab assistant for a long-term contractual period, my lord. Now, my lord,
does the advertisement says that this number of let's take it for one post.
Yes.
Advertisement was floated.
Yes, yes.
And there exists only one post in the department. Or
yes, my lord.
Is that the case?
No, my lord.
You are the incumbent there.
Yes, I am the incumbent
only
there.
One post exists. Only one sanction post.
Only one sanction. At that relevant point of time, there was only one sanction post. I continued to occupy that. Subsequently, another post has come up. Now they advertise both two posts. The one that I'm holding also and plus one. So at least if they want to advertise for the post which I'm not holding. But so now, my lord, I'll just take one more letter, my lord, page 58, my lord, 58.
What is the, again, come back to the order of the learned CAT?
The order of the learned CAT, my lord, the operating part, I would like to read, my lord, is page 54. The operating part of the CAT's order is page 54, my lord.
Yes.
Page 54, my lord, paragraph 18, my lord. The applicant is basically praying for continuation of his contract for 5 years in terms of the recruitment notice dated 28/09/2018. Even otherwise, that 5 years period is coming to an end on 08/07/2024. It is settled law that contractual employee has no legal right to continue beyond the terms of contractual employment. In the case of Shri so and so, so and so. So this is the law laid down, my lord, is saying. Now my contractual obligations is coming to, they said to the on 8th of July 2024. But this advertisement, which I am impugning as selling, my lord, which I'm saying that the CAT was wrong, because it was in the year 2021, my lord, 2021, which sought to replace me with another contractual employee, my lord.
That was in 2021.
2021, my lord. In the year 2021, my lord. And
when have you approached the CAT?
I have approached the CAT.
21 itself.
21 itself, my lord. And the order came up, and the order was delivered in 30th of May 2024, my lord. So which means that when this order was passed, the materials were there. So this is where I was saying that CAT ought to have seen that how can you replace one contractual employee.
The advertisement was state.
I'm sorry?
The advertisement was state?
Initially, the advertisement was my advertisement was not state. My job, the CAT protected me initially for some time. CAT protected me, but
no. So you mean, so you see? Let us be clear.
Yes.
2 posts were advertised.
Yes.
In 2021.
Yes, my lord.
Now you said that that process has not been stayed, so it has continued.
It has continued.
And whether any
no recruitment, no recruitment happened till today.
So
no
process is not completed.
Not completed. That is the reason why I am before my lord also. And now my lord, my suitability and my feasibility to this post, my lord, can be very well understood by page 58, my lord. Page 58, my lord. Let's just have a look at page 58, my lord. Page 58.
That would not be the concern of this court.
No, but this is
it would be incumbent upon the department or the authorities concerned to gauge your performance.
Yes, my lord. This is what exactly they said, my lord. The department they said this. This is what, my lord. So therefore, they have, my lord. Kindly have a look at page 58, annexure 12, my lord. May I read, my lord? My lord has got the papers. Subject minutes of the meeting of FNLA department held on 12 June 2024, my lord. A departmental meeting toward the agenda lasted below was conveyed on 12 June 2024 in FNLA department NIFT Shillong, and on the following members were present. So these are the members, my lord. Agenda: extension of contract of Mr. Shanborlang Kurba, lab assistant and FNLA department NIFT Shillong campus. The following points have been discussed in the meeting vis-a-vis the contract of Mr. Shanborlang Kurba, lab assistant. That the contract of Mr. Shanborlang Kurba will expire on 8 July 2024 as per the information received. That as per the sanction strength dated 17/6/2021, which states that the department should have 1 machine mechanic and 2 lab assistant. Currently, the department has been running the general workshop, wet workshop and leather lab, and all the 3 labs have been handled by 1 lab assistant, that is Mr. Shanborlang Kurba, and will not be able to function in his absence. The department also does not have a machine mechanic, and Mr. Shanborlang Kurba has promptly taken up the additional role for maintaining the repairing and machines in both the dry workshop as well as the leather lab. The lab assistant has been dedicated and resourceful in his role as lab assistant throughout his term and service in NIFT. His adeptness in his skill and contribution to the department is commendable and much appreciated by both faculties and students. The foundation batch is also dependent on the capability of Mr. Shanborlang for the material courses. Mr. Shanborlang has been assisting the students and faculties in the foundation program. Furthermore, the upcoming semester with 3 batches and AD and 4 batches of F&B will require manpower and skills to run the lab. In view of the above, it seems like Mr. Kurba has been playing a crucial role in maintaining the operations of the lab and has taken on additional responsibility beyond his designated role. The department hence feels that an immediate extension of his terms of service may be addressed, as hiring to fill the vacancy might not be feasible in such a short period of time. The department looks forward to the much needed and necessary support for preparing, maintaining the labs, mixing the electrical issues of leather lab, machine and workshop in the summer break, June, July for the upcoming semester without hindering the flow of the curriculum and the classes, my lord. So, my lord, this shows, my lord, this shows my feasibility and more importantly, my lord, there is no adverse remarks against me, my lord. Now, my lord, they have issued one advertisement, my lord. They have not given the date, but this advertisement subsists, my lord. Page 59, my lord. Page 59. Now again it says, recruitment notice the National Institute of Fashion Technology Shillong campus invites application for the below mentioned post to be filled on long-term contract basis. Again, my lord, lab assistant, 2 numbers, my lord. 2 numbers. Now, my lord, again and again, they try to replace an existing person who is already on a contract basis, my lord.
See, Mr. Yubin, this advertisement, like you rightly said, it dates
2021.
2021.
Yes, my lord.
Now, this Annex 8, page 58,
my lord,
is a meeting or minutes of the meeting or resolution of the meeting
2024
in the year 2024.
Yes, my lord.
So, 3 years have passed by since the advertisement was issued.
Yes, my lord.
And then you were given this, this commendation.
Yes, my lord.
Okay.
Yes.
Now, what was the follow-up of this?
No, they have not acted on that. The posts are not filled up till today. The posts are still lying there. They have the institute have not acted on these recommendations.
You could have waited for that then.
I'm sorry, my lord.
You could have waited for that.
No, because, my lord, my wait is becoming infinite. My lord has seen.
No, you see, as of now, even as of today,
yes,
you have not been removed from your.
No, I have been removed, my lord. I have been removed.
Oh, you have been removed.
I have been removed, my lord. I have been removed. I have been removed on 18th June 2024. Immediately, 5 days after the recommendation, my lord. So now they have removed me, and now they want to replace me with another contractor. That's coming back to again the law.
See, once you have been removed.
Yes.
Where is the order?
The 57, my lord. Page 57. They have removed me based on the CAT's order.
Oh, based on the CAT's order?
CAT's order, my lord. My lord, may I just read? In pursuant to the office order so-and-so contract, with regards to appointment as lab assistant for a period of 5 or 6 months on short-term contract, as per order number so-and-so, dated of Central Guwahati bench for maintaining the status quo for your service. As per Central Administrative Tribunal's Guwahati bench hearing dated 03/05/24 and order dated 30th of May 24, the Honorable Court has categorically mentioned in the above order that the applicant has failed to make out a case warranting interference on this tribunal and has dismissed OA. Also, the status quo granted vide order dated 22/6/21 has been vacated. Accordingly, MA 75/21 also stand disposed of in view of your service at MFT as lab on short-term contract issued with dated stands discontinued with immediate effect. The acts as fault on the basis of CAT, which my lord, I just try to persuade my lord that the CAT has overlooked. How can you replace one contractual employee with another contractual employee, especially, my lord, especially in the absence of any misconduct or performance issues? Now, very kindly, the department has recommended.
The CAT has recommended your removal.
My lord, since they say that I cannot make up the case, so my case was dismissed there. So, pursuant to this, pursuant to me losing the case in the CAT, they have removed me. They have discontinued me, my lord. So, this is the gamut and some substance of my grievances, which I came to, my lord, challenge the CAT's order and subsequent. And more importantly, my lord, the main issues, my lord, that I my lord, the question, the issues would be, can one contractual employee be replaced by another contractual employee, especially in the absence of any misconduct or performance issues, my lord?
See, Mr. Yogin, if I understand, okay, subject to being convinced otherwise.
My lord.
But the fact remains that by this order dated 18/6/2024,
Yes, my lord. 2024.
Your services have been discontinued.
Discontinued, my lord.
So matter ends there.
The matter ends there, my lord. Yes.
Now, as far as the matter ends there, and the advertisement of 2021 would become alive now.
It is. It would. Yes. Yes. Yes.
No probability,
yes.
whatever the case may be.
Yes.
Subject to other factors.
Yes, my lord. Yes.
So, which means that as of today,
yes,
or rather as of 18/6/2024,
my lord,
you are no longer in service.
Yes.
A position of contractual appointment exists, which is required to be filled up, and was processed so by the advertisement. That would be, the position, if yes. I understand correctly.
Yes, madam. Now
your grievance are otherwise.
Yes. But the problem here is, my lord, this is an advertisement. This is an advertisement in existence when the matter was before CAT. The CAT would have looked into this, but it went around and say that no, since you are a contractual employee, you have no right to continue. But the question was that was the CAT right? Why did the CAT overlook the principle of law that because that advertisement through which I came also was a contractual employee? Now the advertisement which sought to replacement is also a contractual. It had been a permanent, then the matter could have changed. The dynamics, the diameters could have changed. But it's a contract. It's a contract.
Yes, I think. You're accepting notice?
My lord. But only one thing, my lord. No interim order is called for at this stage because CAT order is of last year, my lord. CAT order is of last year, May 24. He is out of service since 18th of June last year, my lord. He's approaching this Honorable Court now. More than a year, my lord.
Let them file affidavit.
I'll file affidavit.
My lord, let's see that.
And what I remember, my lord, ad hoc cannot be replaced by ad hoc. The contractual, in my submission, can be replaced by contractual, my lord.
Contractual, ad hoc, it's all your nomenclatures.
That was the law laid down in PRA Singh some 1980.
PRA Singh, no, there's
after that, Uma Devi has come, my lord. Now Uma Devi has changed the complete dynamics.
No, after Uma Devi,
even ad hoc cannot be replaced by ad hoc. Is whether there is a good law today. Lots will examine that.
Manish Gupta.
Is good.
Manish Gupta has come.
Contractual.
That's
serious doubt.
And PRA Singh is of 1992.
Yes.
And after that,
Uma Devi, PRA Singh is
gone.
No, Manish Gupta is 2022, my lord. Manish
Gupta. So far as replacement of ad hoc by another ad.
Yes, that is ad hoc.
Yours is not ad hoc.
It's a contractual.
Yours is contractual.
Contractual, my lord.
There is a difference between ad hoc.
My lord. We'll look into my lord. We'll look into directly whether there's more citations. Let them file in the meantime affidavits, my lord.
But though I'm not the advisor, since advertisement says he's eligible to apply, so to apply rather than contesting and spoiling his own case. Without I'm not advisor, my lord.
Prejudice to your case here, you can apply.
He's experienced. He's worked there.
My lord,
you've been given. That's what I was wondering. You've been given such a good recommendation. Why they have discarded you? That may be
my lord,
mechanical.
My lord, my lord, raising my grievances may because my lord, this advertisement till now, my lord, nobody. We don't even know who is applying. There's like so much of uncertainty is there. But besides that point, my lord, I would just like to stick to the points that I've raised, my lord.
Whatever possible from our side.
My lord. Obliged.
But concerning, you have to also understand how, like I said again, it's you have to be pragmatic. You have to look at the benefits that you're getting from his service as recommended or commended by you. And then see if something can be done. Otherwise,
because what happened, he used to come to me on behalf of NIFT for giving letters and all that. I didn't know that he's out of service.
You know him personally. I
didn't know that he's out of service.
All the better for you to help him. But Mr. P. Oben, counsel for the
petitioner,
who has submitted that the petitioner being aggrieved by an order dated 30/5/2024,
My lord.
passed by the Leonard Central Administrative Tribunal in OA number 043/00141/2021, has approached this court with a prayer inter alia for setting aside setting aside and quashing the said impute order. On hearing the learned counsel, we are convinced that this petition is required to be admitted. The same is being done so here. You are with him in this case. Ms. Gurung Larat Counsel has accepted notice on behalf of the respondent. Dr. Enmuzika Larat, DSGI, appearing for the said respondent, has submitted that he may be allowed to file the affidavit in opposition on behalf of the respondent. That's prayed for how long?
3 weeks. 3 weeks.
3 weeks. This is matter up to 3 weeks.
Obliged.
From daily list, item number 1.